Good day, everyone. This is Ms. Morfe. I'll be your instructor for the course of Magistrate Court Practice for the year 2021. I hope everyone is keeping safe in this hard times of pandemic, and I hope I help everyone regarding this course and everyone is able to follow what I'm presenting. Let's start with the purpose and aims of the course. The course enables the candidate to practically understand the civil procedure in the magistrate court, from taking instructions through to appeal and review for effective and successful litigation. It also enables the candidate to be able to advise clients on the prospects of success of a matter, cost implications thereof, and empowers the candidate to draft notices, pleadings, as well as the ability to act in accordance with the ethical rules of the profession. The prescribed tutorial material. The manual contains theoretical aspects of the magistrate courts. There are self-assessment questions included at the end of every unit. They're designed to test your understanding of the material and aspects of the civil process, and candidates need to revise in order to pass this course. There will be formal lectures and trial advocacy sessions for the course. There are a number of written assignments and practical exercises allocated to firms or individual, and there's one final examination. Assignments and assessments. There will be several assignments, mini tests, case studies, which will cover for both motion and action proceedings. In the above process, you will create client files, draft letters, learn to draft pleadings, and be able to prepare for trial. You will write a final examination, of which the date will be confirmed, and in order to pass, you must obtain 50%. Overview of the course. Taking instructions by consulting with clients and perusal of documentation or consulting with witnesses. That is what we mean by taking instructions. Action proceedings commenced by way of letter of demand and summons. The types of summons: ordinary summons, summons including an automatic rent interdict, interpleader summons, combined summons or provisional sentence summons, or divorce summons, which are only issued in the regional court only. Defendant matters are commenced by combined summons, followed by notice of intention to defend, plea, offer to settle, or application for summary judgment, and a request for further particulars to prepare for trial. When pleadings have closed, the matter can be set for trial. Discovery notices, affidavits, or notice to use medical examination can be served amongst the parties. And there's a process called pre-trial. It is used to minimize issues in dispute during trial. The matter goes to trial, and there's leading of evidence in chief, cross-examination, arguments, absolution from instance if the plaintiff failed to prove their case, and judgment is handed down by the court. If the matter is undefended, a request for default judgment in terms of Rule 12 can be done, and the original liquid document should be attached to the application. I'm just going through an overview of applications. There are various applications of notice of motions and ex parte applications. Long form is generally compulsory. The adopted short form is for ex parte or urgent matters, for which notice would defeat the purpose of the relief sought. The short form can be used for interlocutory applications and the like. Every application shall be brought by notice of motion, supported by an affidavit as to the facts upon which the applicant relies on. However, there are instances provided in terms of Rule 55 where affidavits are not necessary or may be dispensed with by the court. The notice of motion must be addressed to the parties or party against whom the relief is sought, and to the registrar or the clerk of the court. The notice of motion in every application other than the one brought ex parte shall be similar from 1A of Annexure 1. Copies of the notice and all annexures thereto shall be served upon every party to whom the notice thereof is to be given. Notice of motion, the applicant shall appoint a physical address within 15 kilometers of the office of the registrar or the clerk of the court, which the notice shall service all documents and such proceedings. State the applicant, they must state the applicant's postal, fast mail, or electronic email address where applicable. And if the respondent wish to oppose to the application, he or she must file a notice of intention to defend within 5 days after receipt of the notice. And if no notice of intention to oppose is given, then the matter should be set down for hearing not less than 10 days after service of the respondent of the notice. And any party opposing a grant order must file a notice to oppose and appoint an address within 15 kilometers of the office of the court, or office of the register of the clerk of the court, or the register or the clerk of the court, at which he or she will accept notice and service of all documents, as well as such parties, postal, fast mail, electronic mail address where applicable. Within 10 days of the service upon the applicant of the affidavit and documents, the applicant may deliver a replying affidavit. When an application cannot be properly decided upon, the court may dismiss the application, make such an order as it deems fit, with a view of ensuring a just and expeditious decision. The court may also direct that oral evidence can be adduced before the court in view of resolving any dispute. Interlocutory and other applications incidental to a pending proceedings must be brought by or notice supported by affidavits. Let's start with taking of instructions. Taking proper instructions is a necessary skill for all legal practitioners. The aim of taking instructions is to obtain all the relevant information and give the client an opportunity to tell their story without any interruption. Explain all the possible legal consequences on the matter, estimate also the legal expenses and how will the matter progress going forward. Advise the client and confirm their instructions in writing. And then there's the file. An effective filing system is important to keep record of all correspondence and documentation of a matter. Keep record of all work done in the file. For example, telephone calls must be noted on the file, client visits, and any correspondence received from another party. Organize sub-files to have quick access to pleadings or witness statements. Obtain the client's account details and provide the bookkeeper to pen an account immediately to prevent instructions from getting lost. Drafting legal letters. Create a neat letterhead for your firm and plan the contents of each letter carefully and provide a reference number for the letter and insert the addressee's reference as well. The words "without prejudice" are used to protect our clients' rights and often appear on correspondence. The writer then often assumes that the contents may not be discussed or may not be disclosed during the trial, that some form of privilege has been established. In the decided case of Naidu versus Marine, a 1978 case, it was decided that correspondence conducted without prejudice in the efforts to settle the plaintiff's claim. In terms of this rule, the defendant objects to any information discussed to be used as evidence and wholly inadmissible, and that every communication deemed to be protected by privilege. Inform your client regularly of the progress made, and a fee must be debited for each and every attendance on the file. And every attendance on the file should be noted on the file, including the time spent on each attendance and the contents of each conversation. It is important to confirm all oral conversations and instructions with your client or opposing party in writing after the conversation. That this can be done so by means of a letter or by a written email. And such correspondence should also be kept on the file. Should your client fail to contact you when requested to do so, fail to attend consultation, or fail to sign necessary documents timeously, or decide to take a certain course of action against your advice, you must immediately put the request or advice in writing and confirm your instructions to proceed with the matter despite your advice. It has happened many times in the past that clients argued that they had never given certain instructions when they had in fact done so. Costs. Practitioners should debit fees when work is done every month, and monthly statements should be sent to the client. It is imperative to enter into an agreement with each client regarding fees from the beginning. How and when will the fees be payable, and the consequences of non-payment, and that payment is expected within a certain period. Immediate debiting of fees has VAT implications. If the account is not paid within 60 days, the firm is liable for VAT on unpaid fees. And if fees are not paid on the matter, no further work should be done on the firm until the account is paid. Demand. Legal proceedings are proceeded by a demand to the party alleged to be in default, requesting satisfaction of the claim within a reasonable period. A party to a contract is in mora when the contract has stipulated a time for performance and the party has failed to comply therewith. To safeguard the plaintiff's costs, ordinarily a demand is not necessary to complete a plaintiff's cause of action and is therefore a natural condition to the issue of summons. In such cases, the absence of a demand merely exposes the plaintiff to the risk of losing costs on the summons issued if the defendant tenders payment within a reasonable time. A demand may be necessary in some cases to complete the cause of action. A demand is unnecessary in a provisional sentence summons in which reliance is placed upon an acknowledgement of debt. Examples: a notice is mandatory in terms of Section 129 of the National Credit Act, or a notice is necessary in terms of Section 3 of the Institution of Legal Proceedings against certain organs of the state, or agreements or leases where notice is required in terms of the specific agreement. In terms of Section 3 of the Institution of Legal Proceedings against certain organs of the state, notice must be served within 6 months from the date which the debt became due. If the time has lapsed, the creditor will have to apply for condonation for such failure to actually give notice within the 6 months. And all court orders against the state must be paid within 30 days of the court order. Now we're gonna go and discuss on jurisdiction. Jurisdiction is the power and competence for a court to hear and determine issues between parties. The magistrate court is a creature of statute, and it has no jurisdiction beyond that one granted by statute. The regional civil court has monetary jurisdiction up to 400,000, and the district court has monetary jurisdiction up to 200,000. And let's look at section 28, jurisdiction in respect of persons. Any person residing or carries on a business in the certain or is employed in the district, all parties consent to the jurisdiction of the court, or maybe when the defendant has no objection to the jurisdiction, when the action is made by the plaintiff. Any person originally resident in the country, not for a period of not less than a year, any person who owns immovable property within the district. When an action is brought against the state, the pleading should be served on the minister of that department, or where the whole cause of action arose within the jurisdiction of the court. Let's look at section 29, the National Credit Act, jurisdiction in respect of certain causes of action at the district where the delivery or transfer of a property, action against an occupier of premises, action arising out of any credit agreement. The regional court division has jurisdiction to hear issues relating to nullity of marriage, divorce, in terms of section 29, the National Credit Tribunal judgments are binding on the magistrate court. In the case of Nedbank versus Matima, it is a 2008 case, the plaintiff ran the risk of being awarded cost on a magistrate court scale, as the claim traditionally falls within the jurisdiction of the magistrate court. So I would just advise everyone as a legal practitioner to actually check or be very, very careful on checking on the specific jurisdiction of a court, on checking all the facts. Motor vehicle collision jurisdiction of the court will be where the collision took place. The bank where a dishonored check is drawn and presented for payment will have jurisdiction. Then let's look at section 30 interdicts. A creditor could attach property to confirm jurisdiction if the defendant has fled the country. An attachment order will be granted by a magistrate court. The court will make such an order once it is satisfied that the defendant is about to leave the jurisdiction or is endeavoring on disposing property in order to defeat the claim of the creditors. A confirmation by the court of an interim attachment of an action operates in terms of section 30, subsection 2. We still continue with the interdicts in terms of section 30. The magistrate court has no jurisdiction in matters where performance is sought without an alternative option of payment of damages by way of interdict, even if parties agree that a magistrate court can hear the matter. The court can grant prohibitory interdicts, mandatory interdicts, but it cannot grant orders or for specific performance in terms of a contract, as well as grant mandament faspoli. Mandament faspoli, in the case of Tukumba, versus the Minister of Safety and Security, it's a 2014 case. In this case, there was a situation where members of the SAPS without a search warrant or a seizure warrant had seized a vehicle whose engine and chassis numbers had been tampered with. And the learned judge explained the legal position in the paragraphs as follows. The essence of mandament faspoli is the restoration, before all else, of unlawfully deprived possession to the possessor. It finds expression in the maxims spolatius ante omnia restenduas est. The spoliation order is meant to prevent the taking of possession otherwise than in accordance with the law. The underlying philosophy is that no one should resort to self-help or taking the law into their own hands to regain possession of their property back. The main purpose of manifest folly is to preserve public order by restraining individuals from taking the law into their own hands and by inducing them to follow due process. This applies equally whether the despoiler is an individual or a government entity or functionary. What are interdicts? Interdicts, this is a judicial process to seek a court order for a person to refrain or perform a particular act. It's a remedy used to protect one from future infringement. The final interdict will be granted if the applicant has a clear right, an injury is committed or reasonably apprehended, and there's absence of any other remedy to the applicant. The court may order attachment of property to confirm jurisdiction against a person who does not reside in the public, provided that the defendant has a beneficial interest on a property within a jurisdiction. As a legal practitioner, create jurisdiction when no other grounds of jurisdiction exist at all. In terms of Section 5 of the Act, provides that jurisdiction parties can consent in writing for the district court or regional court. But if the proceedings are beyond the jurisdiction due to monetary limit, only the court having jurisdiction under Section 28 will have jurisdiction. And the jurisdiction, regardless of the magistrate court jurisdiction, and such consent to jurisdiction will be null and void. So, for example, let's say if the monetary jurisdiction is 400,000, even if there was an agreement that says the jurisdiction of the first court of instance will be the magistrate court, and then such consent jurisdiction will be null and void. The consent must be in writing and it must also be pleaded in the summons. The matter can be transferred from one court to another with consent of all the parties. Let's look at Section 46, matters beyond the magistrate court's jurisdiction and interpretation of a will. A matter which the status of a person in respect of mental capacity is sought to be affected, matters in which specific performance without an alternative of payment of damages is sought, a decree of perpetual silence is sought. The magistrate court has jurisdiction in terms of Section 42 of rendering an account or debatement thereof, and payment of such an account not exceeding the amount of 200 in a district court and 400 in a regional court. Let's look at the exceptions to the rule, or the exceptions to the 400,000. If parties have consented to the magistrate court's jurisdiction in writing to the claim being brought in the magistrate court, an abandonment can be done in terms of Section 38. The plaintiff abandons the portion of his claim in excess of 400,000 limit. Where there is a deduction of the debt to the monetary limit, deduction of an admitted debt, plaintiff deducts from his claim the amount of the debt which he owes probably to the defendant, thereby reducing the claim up to the 400,000. Provisions are other provisions to be applied to overcome jurisdiction. Some of a balance of an account falls within the magistrate court's jurisdiction, even if the main capital was larger than the cost jurisdiction. So it's only the sum of a balance of an account, then the jurisdiction can fall within the magistrate court or the regional court. And there's in terms of Section 38, the abandonment of part of a claim, and the abandoned part becomes extinguishes. It cannot later be claimed, and or a deduction of a counterclaim, or deducting the defendant's counterclaim. In terms of Section 40, splitting of claims is disallowed for recovering the money in more than one action. So you cannot split the client's claim into two in hope to split the claims. If the defendant moves after an action has been instituted, that does not affect the court's jurisdiction going forward. Objection to jurisdiction. A defendant may object to jurisdiction by way of a special plea. A special plea that the court has no jurisdiction. The facts on which the defendant relies should be stated briefly in the special plea. Pertaining to the National Credit Act or debt cancelling matters, it has been held that the debtor as consumer of first respondent cannot consent to the jurisdiction alone. Consent of all the creditors is needed. Let's look at the parties in summons. Every summons shall set the following: the first names or initials of the defendant, the defendant's residence or place of business or occupation address. If the defendant is sued, his representative capacity, such capacity should be stated in the summons, the full names, gender, if the plaintiff is a natural person, and the occupation and the residence or place of business of the plaintiff. When the plaintiff sues as a cessionary, the name and address of the cedent at the date of cession. Companies, educational institutions, bodies incorporated by statutes, and close corporations are legal personalities and have local standing to litigate. The one remaining limitation on the capacity of married persons, men and women, is to sue is that a person married in community of property may in certain respects or instances not institute proceedings pertaining to the joint estate without a written consent of the spouse to do so. Minors lack local standing but are duly assisted by a guardian. A minor is an unmarried person under the age of 18 years who has not been emancipated. Persons who suffer from mental incapacity lack local standing. Where a person lacks local standing, for this reason, it is imperative that a curator ad litem be appointed to represent such person in legal proceedings. However, only the High Court may find a person incapable of handling his own affairs. A curator bonis is appointed for this purpose. Co-partners may sue or be sued in the name of the firm, which such persons were incorporated or were co-partners at the time of the accruing of the cause of action or of the claim. A trust is an oddity. It is not regarded as having legal personality. This despite the fact that it can be the beneficiary under a will. The creditors of a trust cannot execute the assets of the trustees only against the assets of a trust, and that a trust estate can be sequestrated. A trust cannot sue or be sued in its own name. Rather, it is necessary to join every trustee in their official capacity as plaintiffs or defendants. If one of the parties dies or becomes incompetent after the commencement of the action, in terms of Rule 52, 3 and 4, provide for an application to be brought to substitute the executor, trustee, guardian, or any other competent person for the deceased or incompetent party. Let's look at the forms of proceedings. There are 3 types of proceedings. There are action proceedings, application proceedings, and provisional sentence proceedings. Action proceedings are instituted where there is a material dispute of facts, but by way of summons. Application proceedings. In term Rule 55, applications brought by way of notice of motion, supported by an affidavit with the facts of the evidence and instituted where there's no material disputes or facts, and the matter is decided upon the papers presented in the court and no oral evidence is adduced. Provisional sentence summon. This is an extraordinary summary and interlocutory remedy designed to enable a creditor who has a liquid document to obtain a speedy judgment without resorting to the more expensive machinery of an illiquid action. Provisional sentence precludes a defendant with no valid defense from playing for time. Let's look at action proceedings. Action is instituted by way of summons. It can be simple or combined summons addressed to the sheriff. A defendant must file a notice of defend or a notice to defend within 10 days and file a plea within 20 days after giving such notice of intention to defend. Deliver a plea or with or without a claim in reconvention. Simple summons is used for a debt or a liquidated demand from 2 Annex 1 is used. And examples are arrear in rentals, cancellation of a lease agreement, cancellation of a contract. And all the examples are also on page 61 of the manual. Examples of a claim or for a debt or liquidated demand are as follows. An account and debatement of it, arrear rentals, cancellation of a lease agreement, eviction in terms of a cancelled lease agreement, cancellation of a contract of sale, eviction based on cancellation of sale or conclusion of a new agreement, cancellation of an agreement and forfeiture of installments paid in terms of it, an interdict preventing trespassing, failure to pay due maintenance, delivery of property, work done, and material supplied. Every claim which is not a liquidated demand or a liquidated claim, a combined summons is utilized from 2B Annex 1. The summons shall comply with Rule 6 as follows. It should be signed by legal practitioners acting on behalf of the plaintiff, and it shall contain the practitioner's address within 15 kilometers from the court and postal address, email, and fax mail. If the client is not represented, they themselves sign and use the 15 kilometers address from the register or the clerk of the court. Postal address should be included, fax mail, and email. The summons shall be signed by and issued by the register or the clerk of the court and allocated a case number. The plaintiff can indicate on the summons in writing for exchange or service of subsequent documents through email, fax mail. A written request can be made to the plaintiff by the defendant to the plaintiff. But if the plaintiff or defendant refuses, the court can grant such consent on application by the plaintiff. Every summons shall include details of full names, the plaintiff, gender, and if the plaintiff sues in its representative capacity, such capacity. Every summons should include a form of consent to judgment, an appearance to defend, jurisdiction, armament. For example, the whole cause of action arose within the jurisdiction of the court, an averment that the property is within the district or regional. Show any abandonment part of the claim under Section 38 of the Act. A summons for rent under Section 31 of the Act shall be in a form or shall be in the form of prescribed Annex 1, Form 3. Matters to bear in mind when preparing for the particulars of claim with a view of enforcing the debt in terms of Section 34 of the National Credit Act, as from 1 December 2020, a debt enforcement in respect of a credit agreement can no longer be done by simple summons, but rather by using combined summons.